Hello, this is Marvin Swartz. I'm the director of the National Resource Center on Psychiatric Advance Directives, which is supported by a grant from the John D. and Catherine T. MacArthur Foundations. What I'd like to do is to let families know what they need to know about Psychiatric Advance Directives in this presentation. So this is background that will present information about Psychiatric Advance Directives and what families need to know in order to encourage their family members to use them and to be prepared to step into important roles when they're called upon. So at the outset, what are Psychiatric Advance Directives? Well, they are legal documents that allow persons, when they're of sound mind, so if a mentally ill person is well and not in crisis, are not incapacitated, they can make these legal documents. And they're legal documents that can refuse or give consent to future psychiatric treatment. They can also, in addition to the document that may set out their wishes, they may authorize another person to make future decisions about mental health care on their behalf if he or she becomes incapacitated. So as a very important footnote right here, families need to know that what a Psychiatric Advance Directive can do is empower families to help the consumer or patient during times of crisis to step in and make decisions for them when they're unable to make decisions. And so these are very valuable legal tools to help a family member during times of potential crises. The goals of an advance directive are to ensure that patients are treated according to their wishes. And in this case, to ensure that a family member can be called upon to speak for the patient during periods of incapacity and to be able to make sure that their wishes and preferences for treatment are known. The other goals are to encourage a more informed and open dialogue between patients, families, and their treatment providers about treatment. Now, Psychiatric Advance Directives came on the landscape as part of the Patient Self-Determination Act of 1991. That was a law that requires hospitals and clinics to assist in the use of medical advance directives or living wills. Many people don't realize that that law also authorizes, in most states, people to make a psychiatric living will and put it on file in the same way as they can make a living will. Now, there are some states that have set aside Psychiatric Advance Directive laws that are separate from the PSDA. And in those laws, the PSDA, the Patient Self-Determination Act, requires hospitals and clinics to assist in their use. They're also important because they allow families to speak directly with providers during crises. So, during a period of incapacity, when the healthcare power of attorney, which I will discuss in a minute, takes effect, the family is the official designated decision maker for the patient during times of crisis. So it allows families to help make decisions during crises. It still supports patient and consumer autonomy and empowerment in their mental health care because it is a way for families to help consumers to get what they wish during times of incapacity. And as a result, it may reduce involuntary treatment and it may improve continuity of care because the family can step in and help communicate important wishes to providers. There are two parts to Psychiatric Advance Directives. Now, this varies from state to state, and so I'm going to give you some generic information. And then what I would like you to do is to go to your state and see how these work. You'll be able to do that by going to our website at www.nrc-pad.org, and you'll have tons of information there about your specific state. So there are generally two parts to Psychiatric Advance Directives. An instructional directive, which is similar to a living will, so it's just a document in which one writes out one's wishes and consent or refusal of future treatment. Now, usually as a separate piece of law, a separate document, is one that designates a healthcare power of attorney, which appoints another person to make decisions during crisis. So it would allow a patient to designate a family member, for example, or a significant other or a friend, to step in and make decisions during crises. And these healthcare power of attorneys can be designated with limited or broad powers. So, for example, the person can say, I would like my family member to make all my medical decisions and psychiatric decisions when I can't speak for themselves. Or they may say, well, I really only want the person to make psychiatric decisions. So they can customize the healthcare power of attorney to give family members or significant others exactly the types of decision-making authority they wish for times of crises. Now, no one's required to have either an instructional directive or a healthcare power of attorney, but we encourage people to think about it and see how powerful these documents may become. So let's talk just a minute about what the instructional directives are. They are, again, like a medical living will. They're a document that one writes out things and that usually permits an individual or patient to plan for, consent to, or refuse things like hospital admission, medications, electroconvulsive treatment, or other treatments for mental illness. Now remember, these are going to take effect only when the individual loses the ability to make decisions or is designated as, quote, incapable. Now that definition and that term may differ from state to state, but the principle remains the same, that the idea is that the instructional directive or the psychiatric living will only takes effect when the person's designated or termed incapable. The instructions may include other information that isn't about consent or refusal and could be otherwise still valuable, however, because it could have things like who to contact in the case of a crisis, what may cause a mental health crisis, what may help a person to avoid hospitalization, how the person generally reacts to hospitalization, or other instructions. So what the person can do is make a very valuable précis or review of their mental health problems, diagnoses, medications, who to contact, that will be on file during periods of crisis. Now, this is an example from North Carolina on how you make an instructional directive, so you need to check your state. But generally, any patient or person of sound mind can make an instructional directive. It needs to be signed in the presence of two witnesses, not a relative. So in this case, it can't be a family member to witness the instructional directive. So it has to be someone who's not related and not a provider, not a doctor, mental health provider, or staff member of a healthcare facility. It has to be someone unrelated to treatment or the family, just as the witness. And then it has to be notarized, and it's then presented to the doctor or the mental health treatment provider or the facility, and they put it on record so it's available during periods of crisis. The patient can also take it anywhere they wish to put it on file, and we sure encourage people to do that. And in addition, in certain states, there are electronic websites or repositories where they can put these on file so that a provider can go grab them off the web during periods of crisis. And what are the doctors or staff supposed to do with the instructional directive? Well, they need to make it a part of the medical record, and they are required to act in accordance with the instructional directive when the patient is determined to be incapable. So it only takes effect during periods of incapacity. And we're going to define that in a minute. They're also required to notify all other providers to follow the instructional directive when the situation arises. So that raises the question, what does incapable mean? And this is an example from North Carolina. It's going to vary across states, but generally they're very similar definitions. This definition is that in the opinion of a physician or eligible psychologist, the person currently lacks sufficient understanding or capacity to make and communicate mental health decisions. So let's go over that again. It's instructional directive or healthcare power of attorney has no power until the person is designated as incapable. So a physician or psychologist has to write in the chart that this person lacks capacity, is unable to make decisions, and this is sort of an emergency form of incapacity or incompetency that allows people to step in and help the patient. So do clinicians always have to honor the instructions? Here is an example from North Carolina, and it tells you that there are exceptions and there are times that a clinician can disregard the instructions. And those are pretty narrow conditions there when, for example, if the instructions aren't consistent with generally accepted community practice standards. So say a patient during psychosis is requesting, or during a period when they're very, very sick, mentally ill, they request, say, vitamins. Well, the clinician doesn't have to follow that instruction if they think that's not going to be helpful and it's not generally accepted community practice. The clinician also doesn't have to follow the requests when they're not feasible or unavailable. So say the person requests to be flown to another state during periods of crisis and that's not feasible, well, then the clinician may disregard that instruction. And when the treatment request would interfere with an emergency treatment requirement, and they can be generally overridden by involuntary inpatient commitment. So with those exceptions, the clinician has to follow the instructions. But if one instruction is not followed, that raises the question, well, what happens to the other instructions? And generally, if one instruction isn't followed, the remaining instructions still must be honored and followed. And the clinician should document in the chart why they're not following those instructions. Can the patient or consumer change the instructions? Yes. Although the rules might vary across states, generally the instructions can be changed, as can the healthcare power of attorney, whenever the person's competent or capable. So at any period of time when they're not under this designation of incapacity or incompetency, the person can change their instructional directive. Now let's turn to healthcare power of attorney, because this is the piece in which the family has a vital role. What a healthcare power of attorney does is it allows a mentally ill person or any person to appoint someone to make treatment decisions when the patient or consumer is incapable or incompetent. So it allows the family member or someone else to step in and make decisions during periods of crisis. So it's a very valuable way to maintain continuity of care and make sure that your family member is getting the kind of treatment that you agree is best for that person. It can be combined with an instructional directive, but they may be two different forms and you don't need to have both. And any capable adult can execute it in designating healthcare power of attorney. Now, who can serve as the healthcare power of attorney? Any competent adult, 18 or older, can serve as a healthcare power of attorney, but that person can't be providing healthcare to the consumer. The consumer or patient can often also name several people to serve if one is unavailable. So say a family wanted to be the healthcare power of attorney for a patient or consumer, they could designate several family members in order to serve in that capacity. And if one was out of town or unavailable, they could go down the list and pick the next person in case that person wasn't available. So it's a way to have a backup plan to cover any emergency that may come up. The healthcare power of attorney takes effect only when the patient's found to be incapable and continues during that period of incapacity. So when a physician or a psychologist determines that the person's incapable or in crisis, then the healthcare power of attorney takes effect and the family member or other person can make decisions for the incapable consumer. What kind of powers does the healthcare power of attorney have? Well, the healthcare power of attorney designation allows that person to make whatever treatment decisions the consumer usually could make themselves, unless, and this is one caveat, unless the consumer has set it up to limit the authority of the healthcare power of attorney. So, unless they limit the authority, the healthcare power of attorney can have very general powers as designated in that state statute. However, the consumer can also tailor the healthcare power of attorney so that the healthcare power of attorney can make only certain decisions. So, for example, the healthcare power of attorney could have decision-making authority over only psychiatric decisions, only medical decisions, both, or say the patient or consumer could say, well, I want my mother to be able to decide about admitted me to the hospital and which medications to give me, but I really don't want her to decide about ECT or electroconvulsive treatment. So that would allow the consumer or patient to tailor-make the healthcare power of attorney so they're very comfortable with it. What should the healthcare power of attorney do if there's a period of incapacity? Well, they must make the decisions for the patient that are consistent with the person's wishes. So they should read the instructional directive, if there is one, and make decisions consistent with what's in that directive, or make decisions based on what they know the patient wants. So they should clearly have a discussion with the patient or consumer about what their wishes are and follow those wishes during the crisis. They can also discuss and review any treatment information that's available, and they usually can consent or refuse admission to the hospital, medications, or even ECT. So there's a broad range of powers that the healthcare power of attorney can have as long as those powers haven't been limited already in the document. So examples of psychiatric advance directives include advance informed consent to future hospitalization in the event of an incapacitating mental health crisis, the ability to request or refuse future treatments with medications or other interventions, and the authority to appoint a healthcare power of attorney to make these decisions about psychiatric treatment in the patient's best interests. So that raises the question, why don't more patients and consumers have these? Well, one big issue is that families haven't realized they should encourage them. They should really encourage their family members who are at risk of psychiatric crises to complete them. They should help them complete them. They should really talk about the benefits. Now, fewer than half the states have these specific psychiatric advance directive statutes, but usually these same features can be included in a generic healthcare power of attorney statute. So, for example, if your state doesn't have a specific psychiatric advance directive law, and you can find that out by going to our website, you usually still can do that under generic healthcare power of attorney. So you just go in there and use it for psychiatric reasons if your state permits it. Other reasons consumers and patients don't have these is that they are sometimes difficult to complete. The consumers don't know how to do them and need help in going through the steps of finding witnesses, notarizing, understanding what they are, making a good document, appointing people. It takes some thought, takes some assistance. And that help in completing an advance directive may not always be available. But one of our goals with the National Resource Center on Psychiatric Advance Directives is to help people to complete them. And what we'd encourage you to do is to go to our website at www.nrc-pad.org and look up your state and read about how you can do it with your state. We have any forms that are available for your state are right under your state. You can click on them and download them. And we refer you to more information. We have a discussion forum. We have a legal forum. We have all kinds of information that can help you learn more about psychiatric advance directives and consider whether they would be benefit to your loved one. We also have links to other websites, such as our partners at the Bazelon Center, www.bazelon.org, NAMI, www.nami.org. All of these places have very good information about psychiatric advance directives, so you can learn more there. So thanks very much for listening to this presentation, and please come and visit us at the National Resource Center on Psychiatric Advance Directives at www.nrc-pad.org and get more information about advance directives and learn how you can help your family member to access them and use them to help improve their health care, and specifically their mental health care. So thanks very much.